then next question. Right to education is not properly implemented in India. Comment. So in our last class we are discussing about up to right to life and personal liberty. Right to education is related to Article 21A. Right to education is not properly implemented in India. Comment. So whenever they are asking this type of question, we will try to understand what is right to education and why right to education is not properly implemented in India. These type of things are required in this answer. First we will try to write one thing. What is right to education in our answer? In the 21A, 6 to 14 years children is having a fundamental right. That is, primary education is a fundamental right. That is right to education. Constitution provides this opportunity to the 6 to 14 years children. Primary education is a fundamental right. So, right to education is a fundamental right. This 21A is not there in the basic constitution. With the effect of 86th Constitutional Amendment 2002, 21A was incorporated in Indian Constitution. So, this is constitutionally we provide this thing, but even though if they ask the question directly, right to education is not properly implemented in India, just you mentioned in the first paragraph, this is so and so. 21A, 6 to 14 years age group children. Primary education is a fundamental right for the 6 to 14 years age group children. It is incorporated with the effect of 86th Constitutional Amendment. So, whenever Constitution provide fundamental rights to the children who are having 6 to 14 years, why it is not properly implemented? What are the reasons and why it is not properly implemented? We will try to observe one thing. So, every parent and guardian are having a responsibility to send their children to the school who are having 6 to 14 years. It is one of the fundamental duty also. 11th fundamental duty. With the effect of 86th Constitutional Amendment 2002, fundamental rights, directive principles of state policy and fundamental duties are also influenced. Specifically related to this question, Constitution provide fundamental rights to the children. Simultaneously, parent and guardian are also having the responsibility to send their children to the school. So, with the impact of these 86th Amendment, in the year 2009, our Parliament made an act, that is Right to Education Act. This act is implemented 2010 April 1st onwards. So, whenever we are having a constitutional amendment and act, and even it is a fundamental duty, how it is not properly implemented? This is very important. So, in this first paragraph, we will providing this information. Then, with the effect of RTE, Right to Education Act 2010, some specific points are there related to right to education. With the effect of this RTE, in this act, some points are mentioned. Number 1, first point, government is having a responsibility to provide free and compulsory education who are having 6 to 14 years of age. This is the first point. Then the RTE, the ultimate goal of the RTE Act, Right to Education Act, is not only provide the education to the children. Government is having a responsibility to strengthen the children in education and sports and games, and government is having a responsibility to provide the proper health also. Means in government schools, government conduct the health tests also. So, overall development, education and sports and games, and providing health, proper health, means health checkups, frequent health checkups are also part of the RTE. So, we will try to observe one more thing. Earlier we are using the word education minister. Now we are using the word not education minister, we are using human resource development minister. So, we are having a ministry, education, once upon a time. At the time of P.V. Narasimha Rao, he changed the name of that portfolio, that is not in education, it is called human resource development. So in the process of human resource development, we need to develop the children in 360 degrees approach, specifically education, sports and games, and awareness. This is a motto. So because of that, RTE aim the not only education, even the sports and games. Then other of these RTE, government provide the midday meal program to the children. Government provide midday meal program. But one thing, who are economically backward, who are not able to incur, who are not able to spend money for the education, government provide free education in government schools. At the same time, whatever the private schools are there in India, government is having a responsibility to provide some seats in the private schools also. According to RTE, every private school should reserve some seats to the poor children. It is also mentioned in RTE. At the same time, government is having a responsibility to strengthen the skill of the children in different sectors. So these type of positive points we have chance to observe in Right to Education Act, but practically these are not implemented. From the 2010 onwards, RTE is implemented, but even now we have chance to observe crores of child labor in India. Some crores of child labor are there. So this is the first demerit, means it is not properly implemented. Then even in our budget, in our annual budget, government is not allotted proper funds for the development of primary education. This is the second demerit. Then whatever the measures taken by the government for the purpose of implementation of prohibition of child labor system, these are not properly implemented. Just we will try to imaginate one thing. If we implement the Child Labor Prohibition Act in a proper manner, if there is no child labor, 21A is implemented. Otherwise, if we implement the 21A in a proper manner, there is no question of child labor. Whenever all the children who are having 6 to 14 years, if they are studying in the schools, there is no question of child labor. So, 21A is not properly implemented. Because of that, some thousands of child labor, some crores of child labors we have a chance to observe in India. At the same time, in the government sector, different departments try to implement the RTE, but the coordination between the different departments are not properly organized. Means lack of coordination, RTE is not properly implemented. Then what is the salvation for this RTE, for the purpose of implementation of RTE in a proper manner? So basically, education and human resource sector, we are not allocating proper money. If you, for example, if you take the Brazil government provides some money to the children's family whenever they are attending schools regularly. Even now we have a chance to observe these type of programs in some states in India. So whenever we are encouraging the children's parents to send the children to the school, some extent we have a chance to fulfill the RTE goals. Then at the same time, in the present circumstances in government schools, government provide midday meal only. If you provide only midday meal, it is not the salvation. Government is having a responsibility to provide midday meal and tiffin and dinner also. Other of these, we are having some other salvation. Encourage and increase the residential school system in India. Encourage and increase the residential school system in India. Even we will try to create awareness in the society. Then corporate organizations should participate to implement the RTE Act. Means government should made a proper law for the role of corporate organizations in the RTE. Now, according to the corporate social responsibility, 2% profits are allotted. Whatever the corporate companies they are earning profits, on that profit 2% are 2% of profits are allotted for the corporate social responsibility. If you strengthen these and if you mold that according to the RTE, we have chance to do something and we have chance to observe some remarkable change. So other side of this, mindset is also very important. Even now, some parents, they are not aware about the importance of education. So whenever we are creating that type of awareness, we have a chance to implement the RTE in a proper manner. This is RTE is not implemented in India. Comment means because of these reasons RTE is not properly implemented. If we initiate these things, whatever we discuss, we have a chance to implement the RTE in a proper manner. Sometimes they have a chance to ask the question, what is the background of the Right to Education Act and how this Right to Education Act is made by the Parliament? If they ask the question, before the 2010, what type of activities are done in a different circumstances and why this RTE made Right to Education Act made by the Parliament? Why RTE Act made by the Parliament? We will try to observe the answer for that question also. In the year 1992, Mohini Jain versus Karnataka case, Supreme Court delivered the judgment. Higher education is also fundamental right. Higher education is also fundamental right. Higher education. Not only primary education, higher education is also fundamental right. In the year 1992, Supreme Court delivered this judgment. Mohini Jain versus Karnataka case. Mohini Jain was a medical college student on that time. So, on that situation, that college management, they are not ready to continue the Mohini Jain in the medical college because of so many other reasons. So, in the examination, we didn't write anything. Whatever the case background, these type of things are not required. Just you will try to mention a single line, that is, in Mohini Jain versus Karnataka case 1992, Supreme Court delivered the judgment, higher education is also fundamental right. Then so many people, they approach the court. Practically, government is not able to provide the higher education to each and everyone. Because of that, in the year 1993, within the span of 1 year, Supreme Court changed its opinion. In Unni Krishnan versus State of Andhra Pradesh case 1993, Supreme Court delivered the judgment, only primary education. Only primary education is a fundamental right. Whenever Supreme Court delivers this type of judgment, primary education is a fundamental right. From the year 1993 onwards, so many non-government organizations and aware people, they demand for the right to education as a fundamental right. So, after the 1993, with the effect of 86th Constitutional Amendment 2002, 21A was incorporated in our Constitution. In this 21A, specifically they mentioned primary education is a fundamental right for the 6 to 14 years children. Primary education is a fundamental right for the 6 to 14 years children. So, 86th Amendment was done by the Parliament in the year 2002. After that, if we amend the Constitution, we are not able to provide everything. For the purpose of implementation of the Constitutional Amendment, proper law is required. So, in the year 2002, 86th Amendment was done by the Parliament. After that, in the year 2009, RTE, Right to Education Act, was made by the Parliament. It is implemented from the 2010 April 1st onwards. So now this is implemented, but it is not properly implemented. Whatever the points we observe, means according to RTE Act, every 3 kilometers, at least one primary school is required. Government is having a responsibility to strengthen the education, sports and games, and even in private schools, we need to reserve some seats for the poor people, poor children. So so many things are there, but it is not properly implemented. If we take the rational measures to implement the RTE Act, we have a chance to eliminate these type of problems. So this is the history of RTE. Before the act, this is the consequences. So RTE is not properly implemented. We need to implement the RTE in a proper manner. Even though, one more thing we need to observe, if you provide the education, it is not sufficient. For example, we are establishing a school and we are providing education to the children. It is not sufficient. According to the Pradham report, 6th class children, they are not able to multiply 2 digits number, 3 into 7, 4 into 9. These type of multiplications are not done by the 6th class children. So we are providing education, but we are not providing proper education. This is another problem. We are not having a proper schools. If we are having a school, we are not having a proper education. So providing education is important. At the same time, we need to provide the proper education to the children. After that, we provide the education according to the global requirements or not, that is another point. So step by step we will try to observe. First we establish the school and we will try to provide the education. Only midday meal is not sufficient. We will try to establish the residential school system. Then after that, whenever we are providing basic things to the children, after that quality education. Then this quality education means, is it fulfill the global requirements or not? So this is a process to implement the RTE in a proper manner. Then measures to implement the RTE. So next question. Explain the chronology of right to property from 1950 to now. Explain the chronology of right to property from 1950 to now. So what is the chronology? Explain the chronology of the right to property. This is also one of the important question. Once upon a time, they are asking this question as it is, means without any change they are asking this question. Means from the 1950 to now, how the right to property is changed day by day. First, in the year 1950, in the third part of the Constitution, in a fundamental rights, Article 31 was there, that is right to property. Right to property was a fundamental right. At the time of 1950. So fundamental right means, if any fundamental right is violated, we are having right to approach the Supreme Court directly. If it is not third part of the Indian Constitution, that type of facility is not there, we need to approach the High Court, then we need to approach the Supreme Court. So in the third part of the Indian Constitution, right to property was a fundamental right at the time of 1950. Then after the 1950, with the effect of first Constitutional Amendment 1951, in the Article 31, some limitations are imposed with the effect of this first Constitutional Amendment. That is, 31A was incorporated. 31A. What is 31A? We will try to observe. If any activity is done by the government, if it violates Article 14 or 19, people are not having right to approach the Supreme Court. For example, if the government done any activity means, for example, for the purpose of implementation of directive principles of state policy, if any act is done by the parliament, if any decision is taken by the government, on that time, if any individual right to property is violated, he is not having right to approach the Supreme Court or High Court on the grounds of violation of Article 14 and 19. Our Article 14 is violated, our Article 19 is violated. These type of things are not allowed. So, if government made any law for the purpose of implementation of socialistic pattern society, if individual property is acquired by the government, on that time, that person is not having right to approach the Supreme Court or High Court. Our Article 14 and 19 is violated. On this, according to these 14 and 19, I am having a fundamental right. These type of things are not allowed. So they are imposing some limitations on 14 and 19 with the effect of 31A. This 31A was incorporated in the year 1951 with the effect of first Constitutional Amendment. In the same year, 31B was also incorporated. If any individual fundamental rights are, if any circumstances, if Parliament made any law, if that particular individual property is acquired by the government for the purpose of implementation of socialistic pattern society, citizens are not having any right to approach the court on the grounds of violation of fundamental rights. So simply we need to understand, at the time of 1950, right to property is a fundamental right. Even though in the year 1951, right to property is a fundamental right, but some limitations are incorporated. Limitations means, if any individual property is acquired by the government, person is not having right to approach on the grounds of violation of 14 and 19 according to 31A, and 31B is also incorporated in the same year with the effect of first concurrent amendment. Means 14, 19 fundamental right. These things are very important. Then after this, 31C was also incorporated in the year 1971. According to this 31C, for the purpose of implementation of 39 small b and 39C, means for the purpose of implementation of directive principles of state policy, if any individual property is acquired by the government, people are not having right to approach the Supreme Court. That is 31C. In the 31A, violation of 14 and 19 are not considered. 31B, fundamental rights. 31C, for the purpose of implementation of 39 small b and 39C. What is 39 small b and what is 39C? So concentrating of the natural resources is not allowed, 39B. 39C, factors of productions and wealth concentration is not allowed. So for the purpose of implementation of 39B, small b and 39C, if any act was done by the Parliament, even it is violating the fundamental rights, violating the individual fundamental right, on the time citizen is not having right to approach the court. So simply these 31A, 31B, 31C are gradually impose the limitations on right to property. After that, in the year 1978, right to property is removed from the list of fundamental rights. So then now after the 1978, right to property is only a constitutional right. It is not a fundamental right. Right to property before 1978 and now. What is the difference before 1978 and now? Before the 1978, right to property is a fundamental right. Now right to property is a constitutional right. Constitutional right. Then before 1950, before the 1950, if our right to property is violated, we have a chance to approach the Supreme Court or High Court directly. Now, through the proper channel, we need to approach the High Court, then Supreme Court. High Court, then Supreme Court. Next. At the time of 1978, before the 1978, with the effect of government order, means with the effect of executive resolution means GO, government order, individual property is not possible to acquire. Individual property is not possible to acquire at the time of before the 1978. If government is interested to occupy the individual property through the issuing of GO, it is not possible. Even now it is not possible. Not possible. For example, if some capitalist is having some lakhs of crores of property, if government issue the GO and occupy so and so property, we are issuing the government order, it is not having any validity. So through the executive resolution, property is not possible to acquire before the 1978, even now. Then before the 1978, with the effect of Parliament Act, it is not possible to acquire the individual property. Means we will try to observe before the 1978 it is not possible to acquire the individual property through the executive resolutions and through the parliament acts. Now through the parliament act we have chance to acquire the individual property. Now means after the 1978 through the executive resolution it is not possible to acquire the individual property, 1950 before 1978 and now, but through the parliament act we have chance to acquire the property. So we will try to understand one thing. Sir, with the effect of 1970, with the effect of 44th Constitutional Amendment 1978, right to property is removed from the list of fundamental rights and this right to property was incorporated in the 300A in the 12th part of the Indian Constitution. But one thing we will try to observe, how it is possible to acquire the individual property before the 1978. Means through the executive resolution it is not possible to acquire. Through the Parliament Act it is not possible to acquire. How it is possible to acquire the individual property before the 1978? Simply we will try to understand. On the time they done the constitutional amendment. Through the constitutional amendment they are acquiring the individual property if it is required. So constitutional amendment is a difficult process. So because of that in the year 1978 with the effect of 44th Constitutional Amendment they remove the right to property from the list of fundamental rights. So this is the chronology of the right to property. 31A, 31B, 1951, 31C, 1971, 1978, 44th Amendment, right to property is removed from the list of fundamental rights. Then before the 1978 and now what is right to property? If you mention these points it is sufficient for the examination requirements. Next, what is the difference between the fundamental rights and directive principles of state policy? What is the difference between the fundamental rights and directive principles of state policy? Simply we will try to understand the differences between the fundamental rights and directive principles of state policy. Fundamental rights are provided for the development of the individual. Directive principles of state policy is nothing but constitution provides some guidelines to the government. I will try to explain in a simple manner, then we are having some other table also. So some people they write in a simple manner. What is the difference between the fundamental rights and directive principles of state policy? Fundamental rights means rights to the individuals. Directive principles of state policy for the strengthening of the society, for the purpose of social welfare. Directive principles of state policy are incorporated. Fundamental rights means rights of the citizens. Directive principles of state policy means constitution provides some guidelines to the government. And technical differences we have chance to observe. Third part of the Indian Constitution, fourth part of the Indian Constitution, 12 to 35, 36 to 51. And fundamental rights are borrowed from UPSC and directive principles of state policy are borrowed from Irish. These are the basic differences. So anyone can write these points. Then after these important points we need to observe. Fundamental rights are justiciable. Means if any fundamental right is violated we have chance to approach the court. So fundamental rights are justiciable. Directive principles of state policy are non-justiciable. Fundamental rights are implemented itself. Generally, some exemptions are there, but generally fundamental rights are implemented itself. Means it is not required to make any law for the purpose of implementation of fundamental rights. Directive principles of state policy are not implemented itself. If any directive principle of state policy, we need to implement the if we are interested to implement the directive principles of state policy, government made a law. So then fundamental rights establish the political democracy. Directive principles of state policy establish the social and economical democracy. At the time of emergency, fundamental rights are suspended. Directive principles of state policy are not suspended. Fundamental rights are suspended at the time of martial law. Directive principles of state policy are not suspended at the time of martial law also. So we will try to observe the difference in a technical manner. These are negative as they prohibit the state from doing certain things. Fundamental rights. Directive principles of state policy, these are positive as they require the state to do certain things. So in the Lakshmikant, we are having this table. As it is table, this is. So you can simplify these points and you can write. If the in the examination, if they ask the question, you will try to write. So generally these type of questions are not asking, sir, why you are saying these type of questions are not asking, and why you are communicating this information to the students. One thing we will try to observe, these directly these type of questions sometimes they are not asking, but sometimes they are asking question. Half of the question difference between the fundamental rights and directive principles of state policy, and another half they are adding some other question. If they are adding 1, 2 or different parts, and if they make a question with 2, 3 different topics, information is required. So because of that, direct question is sometimes direct questions are also asking, but in the modern times these type of questions directly we are not expecting, related to some other topic they are asking the question. So because of that, information is required. So these are justiciable, that is they are legally enforced by the court in case of their violation. So simply it is justiciable. These are non-justiciable, means it is not possible to legally enforced by the courts. They aim to establish the political democracy. They aim to establish the social and economical democracy. They have a legal sanctions. They have moral and political sanctions. Means if any fundamental right is violated, we have chance to approach the court. So it is a moral and political sanction. Next, political sanction means opposition parties are also demand the government why you are not implementing so and so thing. Next, they promote the welfare of the individual. Hence, they are personal and individualistic. They promote the welfare of the community. Hence, they are socialistic and socio-antrian. Then, they don't require any legislation for the implementation. They are automatically enforced. It required the legislation. The courts are bound to declare law violation of any of the fundamental right as unconstitutional and invalid. The courts cannot declare law violation of the directive principles of state policy. These are the basic differences between the fundamental rights and directive principles of state policy. Next question, what is the conflict between the fundamental rights and directive principles of state policy? So they have a chance to ask the question, what is the difference between the fundamental rights and directive principles of state policy, and what is the conflict between the fundamental rights and directive principles of state policy? They have a chance to merge these two things. Whenever they are asking these type of question, we will try to answer what is the difference between the fundamental rights and directive principles of state policy in tabular manner. Then we will try to provide the information. What is the conflict between the fundamental rights and directive principles of state policy? So, is there any conflict between the fundamental rights and directive principles of state policy? If we observe the fundamental things related to these two topics, in the third part of the Indian Constitution, in Article 31 of the Basic Constitution, right to property was there. Right to property. So, in the fourth part of the Indian Constitution, 39 small b and 39c articles are there. Right to property means every individual is having right to acquire the property and right to preserve the property, wealth, estates, whatever it may be related to the wealth. In 39 small b and 39c, 39 small b mentioned prevention of concentration of natural resources. 39c, specifically 39c, concentrating of the wealth and factors of production is prevented. Concentrating of the wealth and factors of production. If you observe, whenever we are having a right to property, automatically wealth is concentrated and factors of production is also concentrated, because in the society some people, they know how to earn money and they are earning money, and wealth is automatically concentrated. Whenever we are giving an opportunity to the individual through the right to property, how it is possible to implement the prevention of concentration of wealth and prevention of concentration of factors of production. So, these two things are there in the same constitution. Because of that, always Supreme Court tried to protect the individual fundamental rights and Parliament tried to protect the directive principles of state policy. So, finally, the conflict between the fundamental rights and directive principles of state policy The conflict between the fundamental rights and directive principles of state policy leads to the conflict between the Supreme Court and Parliament. Supreme Court and Parliament. So, Supreme Court try to protect the individual, and Parliament through the different laws and different acts and constitutional amendments, Parliament try to think about the welfare of the society. In this process, the conflict between the fundamental rights and directive principles of state policy become the conflict between the Supreme Court and Parliament. In this process, we will try to observe some cases and some constitutional amendments. That is very important. That is very important.